guys hear me okay? Awesome. Good evening, colleagues and guests. And thank you, Cameron, for the invitation to speak. I'm flattered to be here. I appear tonight to convince you no, that President Trump cannot and should not end birthright citizenship in this country. Birthright citizenship embodies America's most fundamental promise, that all children born on our soil will begin life as full and equal members of our national community, regardless of their parents' origins, their status, or their circumstances. This principle has enabled generations of children to thrive, to pursue their dreams, and to build a stronger nation. It is a fundamental right, older than the nation itself. It is firmly rooted in our Constitution and in our legal precedent. And because it derives its force from the 14th Amendment, birthright citizenship is not subject to the whims of any single man, even the president. My opponents tonight, capable as they are, face two insurmountable tasks. They must convince you both that Donald Trump can end birthright citizenship, and that he should. To convince you that he can, they must either convince you that the president can unilaterally suspend, abrogate, or supersede the U.S. Constitution. And because I trust that Amy shares my respect for the rule of law, I don't imagine she's advancing the authoritarian view. Or they must convince you that the 14th Amendment does not actually mean what the text says, what the historical evidence shows that it was intended to mean, or what the U.S. Supreme Court has held that it means. So far, President Trump and his legal team have yet to convince a single federal judge of their argument. I don't expect it will fare much better tonight. Now, if they somehow prevail on that predicate proposition, my opponents must also convince you that birthright citizenship, a cornerstone of the American story, should be eliminated. Without question, its withdrawal would sow chaos, perpetuate inequity, and rob this nation, you and me, of the talents of the children born here. It would deprive us of characters like Kamala Harris, Marco Rubio, and South Carolina's own Nikki Haley. Now, before I fully begin, I have to admit at the outset that as compared to my outstanding opponents, I have spent much less time with the question tonight. Amy Swear is a writer, scholar, and senior legal fellow at the Heritage Foundation. And from the outside looking in, it appears that Amy has played a pivotal role, both in incubating and giving credibility to the arguments now advanced by the Trump administration in defense of his executive order. Greenville Rigby is a second-year law student at USC School of Law. She spent last summer as a constitutional law fellow at the Constitutional Law Center at the School of Law. And in addition to clerking for the South Carolina State Judiciary Committee, Greenlee serves on the editorial staff of the USC Law Review. She will be a board member for the Lincoln Douglas Society next year and will spend this summer at Nelson Mullins. We give a round of applause. I, by contrast, am a litigator and civil rights generalist. I have plenty of experience litigating the Constitution more broadly, but no special expertise when it comes to the Citizenship Clause of the 14th Amendment. That said, my hope tonight is to explain in simple terms why every federal judge, regardless of who appointed them, has ruled that no, President Trump cannot end birthright citizenship. To do so, I will walk us through the text of the 14th Amendment, the historical context of its enactment, and the landmark Supreme Court cases that have embraced the view that if you're born here, you're American. So let's start with the text. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens. By its plain terms, this grants citizenship to every child born on U.S. soil with a single lone condition. They must be, quote, subject to the jurisdiction thereof. So what does that mean? Most naturally, an individual is subject to the jurisdiction of the United States when there is a legal obligation that they follow U.S. law, to follow its criminal laws, to pay its taxes, to abide by its regulatory regimes. To unpack this, let's start by who's not subject to to the jurisdiction thereof. The paradigmatic example of who this does not cover is the diplomat. Foreign diplomats are in the United States as representatives of other sovereigns. As a result, they enjoy diplomatic immunity from taxation and from both civil and criminal prosecution. The State Department can expel a diplomat, but they cannot be arrested, tried, convicted, or sentenced. Their children, like diplomats, are in a fundamental way outside the jurisdiction of U.S. law. By contrast, the categories of children excluded by President Trump's executive order are unquestionably subject to the jurisdiction of this country. Those present with temporary legal status, those students on student visas or work visas, they pay taxes. They can sue and be sued. They certainly must follow state and federal criminal laws. The same is equally true of those in this country without lawful status. It is estimated, for example, that in 2019, undocumented immigrants paid roughly $5.9 billion in income tax, $16.2 billion in Social Security tax, and $3.8 billion in Medicaid tax. President Trump clearly also believes that such people are subject to our jurisdiction. He recently released yet another executive order encouraging the pursuit of the death penalty in death-eligible crimes when the defendant is undocumented. President Trump and his allies can't have it both ways, because temporary residents and undocumented immigrants are and always have been subject to the jurisdiction of this country. Their children born on this soil are U.S. citizens. Now, my opponents would claim that originalism compels a different result, so let's look at the history leading up to the enactment of the 14th Amendment. The idea of birthright citizenship, as Amy mentioned, is old. It's thousands of years old. It goes back to the ancient world. Since the ancient world, citizenship has been tied either to birthplace, use sol, right of the soil, or to parentage, use sanguinis, or right of the blood. And without question, the English common law tradition was use soli. That tradition was imported to the United States, and from the founding, birthright citizenship was, without question, the uniform assumption in the United States. In 1789, for example, James Madison wrote that it is an established maxim that birth is a criterion of allegiance. Birth, however, derives its force sometimes from place and sometimes from parentage, but in general, place is the most certain criterion. It is what applies in the United States. It will be therefore unnecessary to investigate any other. Now, despite the unquestioned American embrace of birthright citizenship, and even the Constitution's use of phrases like natural-born person to explain who can be president, there's actually no explicit codification in the original text of the Constitution about what makes a citizen. It wasn't until about 70 years later when history presented a dilemma that required the clarification of this principle, and that was the 1857 case of Dred Scott. Now, in Dred Scott, I'm sure many of you are familiar, the Supreme Court considered whether the children of freed slaves who were born in the United States were U.S. citizens. And in answering no, the Supreme Court not only penned one of the most repugnant legal rulings in U.S. history, but it also significantly abrogated for the first time the concept of birthright citizenship. But even following Dred Scott, primary sources show that there was not some sort of widespread corporate withdrawal from the principle of jus soli. In 1862, 5 years after Dred Scott, but still 6 years before the 14th Amendment, Edward Bates, who was the Attorney General to President Lincoln, wrote these words to the Secretary of State and later Chief Justice, S.B. Chase. As far as I know, Mr. Secretary, you and I have no better title to the citizenship we enjoy than the accident of birth. The fact that we happen to be born in the United States. And our Constitution, in speaking of natural-born citizens, uses no affirmative language to make them such, but only recognizes and reaffirms the universal principle common to all nations and as old as political society, that the people born in a country do constitute that nation, and as individuals are natural members of the body politic. If this be a true principle, and I do not doubt it follows that every person born in the country is, at the moment of birth, prima facie, a citizen. Now this leads us, of course, to the 14th Amendment itself. And in a clear rebuke of Dred Scott, as Amy concedes, the Citizenship Clause of the 14th Amendment reaffirmed the national tradition of jus soli, that if you are born in America, you are an American. But it is wrong, as my friend does, to stop there. The congressional debates surrounding the Citizenship Clause were not exclusively about the question of freed slaves. The debate spilled beyond the question of slaves in the South and asked the question very specifically, what of the Chinese pouring into California? Do we mean them too? And the debate ended with a final dispositive yes, them too. Now that brings us to Wonky Mark. In 1868, the U.S. Supreme Court was forced to interpret the same provision we're all here talking about today. What does it mean to be subject to the jurisdiction thereof? That case arose when a U.S.-born man of Chinese immigrants was wrongfully denied re-entry into the country. So he'd been born in San Francisco to Chinese immigrants. He left the country as an adult to visit family back in China and was stopped on his way back into his home country. And the question became, is he a U.S. citizen? Now I want to stop really quickly and reflect on some of the whys that Amy was asking. Why, she asks over and over. Why are these counterexamples if our corporate understanding of jus soli is so firmly rooted? How could there possibly be people who ever thought something else? I would point out that Wong Kim was rejected. He was denied re-entry. It took going to the Supreme Court to vindicate the law here. Plessy versus Ferguson was after the 14th Amendment. Does that make it good law? Does it make it a better representation of the fundamental protections of equal justice than Brown? No, certainly not. The 14th Amendment can stand for a robust view of universal birthright citizenship, and it also be true that broken people across the history of our country, for noble or ignoble reasons, wanted to exclude people in violation of that law. Now, to answer the question, what is subject to the jurisdiction thereof, the Supreme Court looked closely at the text of the 14th Amendment, the original meaning, the legislative debates that led up to its enactment and ratification. Essentially, looking at all of the materials that Amy made available to you, including many others, and concluded as follows. The 14th Amendment affirms the ancient and fundamental rule of citizenship by birth within the territory, including all children born of resident aliens. And while it's true that the question of undocumented immigrants was not squarely before the court in Wong Kim Ark, that was put to rest too. A century later, in Tyler versus Doe, all 9 justices agreed, albeit in an Equal Protection Clause case regarding access to education, that illegal aliens are undoubtedly, quote, subject to the jurisdiction of the United States within the meaning of the 14th Amendment. Now, my opponent did a fantastic job, but there's a reason that her position has been so uniformly rejected by the federal bench. The 14th Amendment prohibits President Trump, whether for good or sinister reasons, from restricting birthright citizenship to a child born in this country. I never thought I would say this, but to quote Judge James Hill, a Trump-appointed judge on the Fifth Circuit and one of the most extreme conservative voices in the federal judiciary, quote, nothing in text or history suggests that the drafters intended to draw distinctions between different categories of aliens. To the contrary, text and history confirm that the Citizenship Clause reaches all persons who are subject to U.S. jurisdiction and laws regardless of race or lineage. I ask you to vote no to the proposition.